Hello everyone, welcome to the 160 Literary and Jury Charge. We're going to start off with an article on the metals. Ready? Silver has been known to man almost as long as gold and is almost as abundant as gold, but it is the whitest of all metals. Silver has caught the eye of artisans and craftsmen. Silver is harder and stronger than gold and is an excellent conductor of heat and electricity. Silver melts at 960.8 degrees centigrade and boils at 1950 degrees centigrade, emitting a blue vapor. Copper was discovered, like its other sister metals, during the Stone Age. Along with iron, copper is one of the most widely used metals. Copper is second only to silver in its ability to conduct heat and electricity. Because of its abundance and strength, copper is used for everything from electric wire to pots and pans. Bronze is an alloy of copper. The single metal the world depends on most is iron. When certain other elements are added to iron, steel is created. Iron is the fourth most abundant element in the Earth's crust. The strength and hardness of iron are twice that of gold. Iron melts at 1535 degrees centigrade and boils at 3000 degrees centigrade. Okay, I've got some jury charge. And the subject is admission of evidence. Okay, admission of evidence. And I will read this at 160. Okay, here we go. Prosecutions for conspiracy present difficulties and temptations familiar to anyone with experience as a federal prosecutor. The difficulties derive from observance of the rules governing evidence admissible against some, but not all, defendants in a criminal case. The temptations derive from the advantages of prosecuting in one trial two or more persons collaborating in a criminal enterprise. One of the most recurring of the difficulties pertains to incriminating declarations by one or more of the defendants that are not admissible against others. The dilemma is usually resolved by admitting such evidence against the declarant, but cautioning the jury against its use in determining the guilt of the others. The fact of the matter is that too often such admonition against misuse is intrinsically ineffective, in that the effect of such a non-admissible declaration cannot be wiped from the brains of the jurors. The admonition, therefore, becomes a futile collocation of words and fails of its purpose as a legal protection to defendants against whom such a declaration should not tell, while enforcing the rule of admitting the declaration solely against a declarant and admonishing the jury not to consider it against other defendants. Judge Hand, in a series of cases, has recognized the psychological feat that this solution of the dilemma demands of juries. He thus stated the problem, quote, "In effect, however, the rule probably furthers rather than impedes the search for truth, and this perhaps excuses the device which satisfies form while it violates substance, that is, the recommendation of the jury of a mental gymnastic which is beyond not only their powers but anybody else's," end quote. It may well be that where such a declaration only glancingly, as it were, affects a co-defendant who cannot be charged with the admitted declaration, the rule enforced by the court, in this case, does little harm, not to leave its application to the discretion of the trial judge. But where the conspirator's statement is so damning to another against whom it is inadmissible, as is true in this case, the difficulty of introducing it against the declarant without inevitable harm to a co-conspirator, the petitioner in this case, is no justification for causing such harm. The government should not have the windfall of having the jury be influenced by evidence against a defendant which, as a matter of law, they should not consider, but which they cannot put out of their minds. After all, the prosecution could use the confession against the confessor, and at the same time avoid such weighty unfairness against a defendant who cannot be charged with a declaration by not trying all the co-conspirators in a single trial. It is no answer to suggest that here the petitioner defendant's guilt is amply demonstrated by the uninfected testimony against him. That is the best of reasons for trying him, freed from the inevitable unfairness of being affected by testimony not admissible against him. In any event, it is not for an appellate tribunal to know how the jury's mind would have operated if powerfully improper evidence had not, in effect, been put in the scale against the petitioner. All right. Here we go. Ready? They lifted the front of my vehicle off the man who was wedged underneath, face down in the street. 2 detectives in an unmarked unit appeared almost at once. A patrolman arrived in seconds. He leaped from his squad car, sprinted to the man, lifted his head, then dropped it back onto the pavement. "Oh," he said as he slowly straightened up, wiping his hands on his pants, "it's only Marty." I fished for my phone in my purse and grabbed my phone to call my mother. A detective looked at me and pointed to the phone with a finger. "No need to upset your folks," he said. "Now, how fast were you going when you saw the man lying in the street?" "He was walking," I said. "I hit him." To my surprise, they neither took me to jail nor gave me a ticket. The detective who drove me home tried to be comforting. "My insurance company would pay to repair my car," he said. I saw no damage. All I could see was that man lying in the street. The medics had splinted his leg. It must have been broken. When they lifted him into the ambulance, he looked unconscious. I was puzzled. The police seemed to be treating the victim in a rather weird fashion. The detective explained it to my mother. The man I ran over was Marty Beale, the town's most arrested drunk, jailed hundreds of times. So far that year, and it was only August, he had been run down in the street 7 times. His most recent accident involved the bus, which ran him over as he lay in the gutter breaking his leg. The morning of our encounter, he appeared before a judge who released him in exchange for the promise he would never drink again. He walked over to Mill Street, earned a few dollars washing cars, and bought a jug of wine to quench his thirst on that hot summer night. Residents called police soon after to complain that he had shed his clothes and was strolling naked in the street. Afraid to jail him again so soon after his release, they simply ordered him to get dressed and move on, which he did moments later into the path of my car. At least he was wearing clothes at the time. I spent a sleepless night worrying about his injuries. I was stunned the next morning to see that the hood of my car was dented, the grille mangled, and that his head had shattered the windshield. I took a bus to the hospital carrying books and candy. His bed was empty. "Why are you looking for him?" a nurse asked. "I hit him with my car last night," I said. She screamed with laughter and asked about damage to my car. "It must have been like hitting a bull moose." He had sobered up and been released. I hoped to keep the accident secret from my co-workers, who often teased me because I was young and shy. but when I picked up the morning paper, there was a photo of Marty sprawled in the street in front of my shiny little car. The headline said I hit him 3 times, with the fender, with the windshield, and then with the entire car. I ran him over. The story was meant to be clever. It mentioned his record, the bus, and my name. I recalled a splash of light that I had assumed was the police shooting pictures to use against me. But a newspaper? How on earth, I wondered, do reporters ever get these things? Poor man. All right, I've got some land description. All right, here we go. Ready? The existing city limits of said city to the intersection with the westerly production of the north line of Lot 25 of Fig Garden Estates, number 11, as said lot is shown on the map thereof, filed in the office of the County Recorder April 8, 2015, and recorded in volume 17 of plats at page 65, Deschutes County Records, thence easterly along the westerly production of the north line of said lot 22, and along the north lines of lots 22, 23, and 24 of said Fig Garden Estates number 12, and along the north lines of lots 22, 23, 24, and 25 of Fig Garden Estates number 19, as said lots are shown on the map thereof, filed in the office and the County Recorder's Office, March 13, 2007, and recorded in volume 19 of plats at page 16, Deschutes County Records, and along the north lines of lots 36 to 40, inclusive of Fig Garden Estates number 2, as said lots are shown on the map thereof, filed in the office of the County Recorder November 7, 2012, and recorded in volume 16 of plats at page 6, Deschutes County Records, and along the easterly production of the north line of said lot 40, being also along the existing city limits of said city. All right, so we're going to stop there. There's more, but I will finish that up in the next class. I know that is difficult. All right, so I've got a speech here. Okay. All right. Here we go. The theme of our meeting today is indeed timely. We as teachers of the English language have invited ourselves to consider getting back to basics, but as we know, there is hardly agreement among us about what is basic to the teaching of our language. Nevertheless, there has developed among us a feeling that we, as teachers, have gone astray, and we have gathered here to examine what is really basic. I, for one, am quite pleased to respond to that question, and I will tell you why. 2 years ago, I was terminated by the small college at which I had been director of freshman writing for 5 years because I did not hold a PhD degree. That gave me the chance to return to the real world. I now have the title of senior planner for my employer, but I continue to teach basic English 1 evening a week to bank employees. It is from this real-life perspective that I present to you today my design for getting back to basics. I think it is right on this occasion to reconsider some famous American persons and words to rediscover what basic reminders they have for us. Let us begin with a bit of Benjamin Franklin in an excellent piece of writing of his where he reveals some very significant things about the ability to write. He tells us, first of all, how his own ability to write was in large part responsible for his advancement in the world. In Franklin's words, as prose writing has been of great use to me in the course of my life and was a principal means of my advancement, I shall tell you how I acquired what little ability I have in that way. He also says with Simpkins, I sat down to put my arguments in writing, and this was to teach me method in the arrangement of thoughts. Further on, he shares with us an event in his life that again emphasizes the benefit he gained from being able to write. Our debates possessed me so fully on the subject that I wrote and printed a pamphlet on it, entitled The Nature and Necessity of a Paper Currency. It was well received by the common people in general, but the rich men disliked it, for it increased the clamor for more money, and they happened to have no writers among them that were able to answer it. Their opposition slackened, and the point was carried by a majority in the House. My friends there, who received that I had been of some service, thought fit to reward me by employing me in printing the money, a very profitable job and a great help to me. This was another advantage gained by being able to write. Franklin also tells us that he attended a grammar school. He went there at the age of 8, attended for a year or so, and then transferred to a school for writing and arithmetic. Today, Benjamin Franklin could not attend a grammar school because they don't exist anymore. Try to discover a school by that title operating today. You will have a difficult time finding it, or ask any 3 people where grammar school fits into the grade structure 1 through 12, and you will get 3 different answers. There is a great deal of confusion about where it fits into the traditional grade school structure, but don't blame the average citizen for this confusion. Even the dictionaries do not agree. They sometimes equate grammar school with elementary school, and often the elementary schools can't agree on what is elemental. Just try it sometime. If you would like to see for yourself the total confusion that attends this subject, consult any 3 people or any 3 dictionaries on the matter. Webster's comes as close to the mark as any, I think. It defines grammar school as the grades between the primary grades and high school. I went to such a school. It was an aspect of school at that time that occurred during grades 5, 6, 7, and 8. It also occurred during the 1950s, 60s, and 70s, along with the 80s, and does not occur now. After grade 8, high school followed. The procedure was that structural, that basic. It worked rather well. For me, it is sad to note the passing of that era. We were taught in those days by teachers who knew their grammar. They also knew from common sense that some difficulty in life is certain and that learning requires effort. They stressed rules and regulations and drill as an orderly means to the end of knowing the basics, and I thank them today. Today, grammar school has gone away, fallen through the cracks in American education made by the incursions of middle schools and junior high schools. So too has schooling and concepts of grammar slipped away. In 1776, Thomas Paine wrote his pamphlet Common Sense. In clear and concise language, he argued that the time for independence had come, and so engaged the American mind to that reasonable cause. But in recent years, far from common sense, we have been hearing utter nonsense from some educators about the right of students to their own language. Such nonsense is the prescription not for a return to the basics, but for a journey into chaos and confusion, a modern Tower of Babel. All right. So we don't have much time left, but I am going to close with some jury charge. The subject is Highway Traffic Act. Ready? Members of the jury, each party in this case charges the other with violating certain statutes of the Highway Traffic Act. It is the law of this state that a violation of any of the provisions of the Highway Traffic Acts by a person operating a motor vehicle upon a public highway shall be prima facie evidence of negligence. This presumption of negligence, however, may be rebutted by evidence showing that the statute in question was not violated, or by evidence showing a reasonable ground for such violation. The driver of a motor vehicle whose vision is obscured by snow and wind or other atmospheric conditions must exercise care and caution commensurate with the situation. The factors to be considered when determining a driver's negligence are the speed and control of the vehicle, the extent of visibility, and the degree of care and caution required under these circumstances. It definitely appears that both motorists were driving at a speed lower than the maximum permitted under the Highway Traffic Act, but the fact that the speed of the vehicle is less than that permitted by law does not relieve the driver from the responsibility of reducing speed when special hazards exist with respect to weather, visibility, or highway conditions. It was the duty of each of these drivers to keep his vehicle in his own lane of the pavement. This collision could not have happened if each had done his duty in that respect. It is for you jurors, as judges of the facts, to determine where and how this accident happened and who was to blame, whether both drivers were guilty of negligence, which substantially contributed to cause the accident, or if weather conditions alone were responsible. Should you find that both drivers were guilty of violation and the violation by each was a proximate cause of the accident, then neither party can avoid liability. All right, so that concludes our literary and jury charge for the 160 class. Have a great day.